Hello viewers, this is attorney Naresh Gehi, and very often I see situations wherein Indian nationals get deported back to India. So when does that happen, how does that happen, and what are your options? Number one, I've seen situations wherein a lot of family members have been deported to India. So it's very sad, it's very disheartening when these things happen, and that can be because of several reasons. And one of the reasons is that you lived in America and you may have crossed the border and you were single and you did not have any immigration relief, and Immigration and Customs Enforcement, that is the deportation authority in America, put you on a plane and send you back to India. But now your mom had sponsored you in the past, or you got married to somebody, or your spouse is a US citizen or a green card holder. In such instances, you may have hope of coming back to America because you have a relative here. And your relative can be a mom, it can be a father, it can be a US citizen spouse, or it can be a green card holder spouse. So if you're in that situation when you have been ordered deported, that does not mean that you don't have a chance. US immigration laws allow for a waiver. They allow us to apply for a waiver under certain situations. Depending upon your situation, you may be eligible for a waiver. Now, take an example that you were living in America and immigration came and raided your house. They picked you up. You're living with your US citizen girlfriend over here, and now they picked you up and they deported you to India. Now, if this US citizen woman comes, she marries you, and she goes back, you may have some hope of coming back to America. Your parents are in the US, they are green card holders, they are citizens, and you have a clean record, and you got deported to India. You may have hope in such cases. So if you have been ordered deported, does not mean that you don't have any rights. You may have rights to apply for your case, but ultimately it's going to be up to the US consulate to see whether a waiver should be exercised in these cases. And there are different kinds of waivers in America. So you have a 212 waiver under which you can apply for hardship to parents, to your spouse. So that's a very important waiver, and the parents have to be US citizens or green card holders, or your spouse has to be a green card holder, or she has to be a US citizen. So look into the fact whether basically you have been ordered deported, or there have been times wherein people have lived in America and they've gone back after accruing unlawful presence, which means you got the 6-month visitor visa. Then after that you left America after 3 years, and now you're sad that you cannot come back to America. But you have this lady or you have this man who wants to marry you, and they have married you, and you're stuck because of your unlawful presence under 212A9 of the INA, of the Immigration and Nationality Act. So in such instances, these cases are complicated, but this does not mean that you don't have rights to apply. So you may still have rights to apply to come to America, and ultimately the consulate will decide whether you warrant a visa, an immigrant visa, or not, depending upon the facts and circumstances of your case. So remember, if you have been ordered deported, or if you have been in unlawful status in the United States, like you came into the country on an asylum, you are stopped at the border, and you left back, or they send you back to India, you may still have rights. So depending upon the facts and circumstances of your case, you may be eligible for a non-immigrant visa or an immigrant visa. So if you have been ordered deported, there may be light at the end of the tunnel, depending upon the facts and circumstances of your case. Or even if your non-immigrant visa was denied while you were trying to enter the United States at the border, and your visa was refused for no apparent reason, you may have rights.